years in domestic violence program, really in the trenches both as an advocate and as an attorney. And I do recall that during the early part of my career working with survivors, that I really didn't have a lot of training on sexual violence, and wasn't always asking the right questions when I was doing initial, interviews with survivors, and didn't really even know that there were EEOC remedies that were available to so many of the women that I was working with, even when I was asking the right questions. So I know that over the years, I'm sad to say that I missed, those opportunities for the women that I was working with and advocating for. And so that's why I think that this topic is really important, even for those of us and those of you who are seasoned advocates who feel comfortable asking about sexual violence. It may be that you're in a community where you don't have a link to the local EEOC office. So we're going to talk about some of that throughout the webinar, and really at the end when we talk about how we can be more engaged and collaborate better with great people like Bill. So I have just a few slides to go over, and I think I'm responsible for my own slides, right? Or Nancy, can you forward my slides somehow? It's not. Oh, there it is. Okay.
Oh,
so
are you able to forward them?
Yes. Can everyone see? Can you see this, Nancy? Now that I'm on the potential challenges. So I just
hello.
The next.
Hear me?
Hello.
Yes. Hi. I'm unable to see anything. Maybe I haven't logged in properly.
Are you in iLink? May I have your name?
I am Lakshmi. I am standing in for Vyoma
from
Daya in Houston.
Okay. Vyoma, let me. I'm sorry, Lakshmi. Can I email you instead, and we can move this offline?
Okay.
Thank you.
Thank you.
Hello, it's Trish from Houston. Can you email me too? Because I didn't see anything.
Okay. My apologies, everyone. One moment.
Hello. Hello.
Hello. Yes.
Yeah, this is Lakshmi from Asha Kiran. We don't have access to computer today, so we are listening on the phone. Can you please email me?
Yes, I will do that. Thank you.
Thank you.
I think we will probably have to mute everybody again.
Okay.
Sorry about that, just for those folks that are. And then if you could, if you could either email Nancy or public or private chat her if you're still having problems. We apologize for our technical difficulties.
Okay, go ahead,
for those of you that can see a computer screen, I'm on the slide about potential challenges for domestic violence advocates. And so I think, let's be honest that for many of us in the domestic violence field, and I think, advocates in general, unless we work in sexual violence, on an ongoing basis, and we have a lot of training, many of us feel uncomfortable talking about sexual violence, and this is also true from a cultural perspective. We just recently had a summit for the API Institute in which we discussed this, and the majority of the Asian Pacific Islander advocates there were saying that, just based on your upbringing, it's hard to talk about issues that have to do with sex. And so how do you ask questions about them? And so I think that that's something that we have to struggle with, both in terms of how we change the culture of our organizations, and also in terms of how do we do training, conduct training and engage in ways that, because I think for myself, working with sex assault survivors at university and the university setting, if I hadn't had so much life experience and then had extensive training, I don't think I would be able to pick up some of the nuances of the kinds of sexual coercion that occur with the women that I'm working with, who are either in intimate partner settings or in academic settings, or even in workplace settings. So I think it's really important that we think about what are some of our individual barriers to addressing sexual violence issues generally, and then specifically as they might relate to a civil right remedy like an EEOC claim, which Bill is going to talk about later. And on that note, I think that it's important, and for those of you that may be on the call that actually have authority to conduct training, or our trainers yourselves, or our managers, one of the things that that when I was working in the domestic violence field, once I met Bill, he connected me with the local Honolulu office here, the EEOC office, right away. And not only was that connection really important so that I could call the local office and get information about remedies, but also because that collaboration led to some really successful training and cross-training between the EEOC and the domestic violence movement locally here. So I'm just going to go on to the next slide. The other, sort of elephant in the room is that our movements and our work is so compartmentalized, and I know many people have heard this critique, but we're in our silos, and we're not thinking about the various kinds of other ways that the women and men and children that we work with are traumatized, and the various kinds of perpetration that occurs. So I think it is really important to try to think about how we can bridge some of those gaps. I know some people on the call are from sexual violence organizations, which is great, and some who do both domestic violence and sex assault. For those who are in solely domestic violence organizations, I think it's important to have staff discussions about what sexual violence is and how do we address it in an interview setting. What is our agency equipped to do to address, a disclosure from a survivor? What are the things that we can do to support that survivor responsibly? And I think that's really critical in thinking, especially if you're just starting off in this work. And on that note, sort of the limiting role of advocates, right? So when we are sometimes working in agencies that we only have a certain menu of what we can do, it's really difficult because sometimes that's the priority. I mean, Bill's going to talk a little bit later about how he started doing this work with farm worker women, that what is the actual priority of need for the women and the communities that we work with. And oftentimes, even though they're identified as a DV survivor, domestic violence survivor, or they're dealing with intimate partner violence, they may also be dealing with sexual violence by both the intimate partner as well as in the workplace. And when we're working in immigrant communities, so many of the survivors that we're working with, many of the settings that they're in are dangerous spaces, because we know that sexual violence, occurs everywhere. So the next slide, I'm really giving just some examples of sexual harassment and sexual violence. Bill is going to go into much more detail about the definition of sexual harassment under the federal law. But these are some of the things that I wouldn't have necessarily thought of when I thought about sexual assault. I mean, we're all really familiar and with the term rape and sexual assault. Sexual violence is sort of more sort of a broader conceptual term, which I really like to use because sometimes we don't know, or we get stuck on legal terms like sexual harassment or sexual misconduct. And sexual violence is something that I broadly like to think of as any sexual act or an attempt to obtain a sexual act, or even unwanted sexual comments or advances by a person regardless of the relationship to the victim. So we know that in domestic violence relationships that there's lots of sexual violence, not only for sex or sabotage of birth control, but also things like that are on the screen here, forcing the intimate partner, the survivor, to have sex with somebody else, or to record sex acts without her consent, or to have her engage in various kinds of sexual activity without her consent. But I think it is important to think about the ways in which the women that we work with are coerced and exploited, and really think very broadly of sexual violence, and ask those questions as they relate to the batter, to the intimate partner. And of course, think about a set of questions that we could ask about the workplace. So I'm going to just finish up by giving this context by talking about the potential role, something that you could think about as you hear Bill's lecture. that there is a huge role that we could play as domestic violence and sex assault advocates in identifying EEOC remedies. I know that for the women that I work with, that we're able to, access our state Hawaii Civil Rights Commission as well as the EEOC, that being able to get that monetary support or having this other sort of authoritative body that believes you, that's taking your quote unquote complaint, and then also, like I said earlier, sometimes the woman that you're working with may feel that the workplace issue is much more dangerous to her than what's going on at home, and that's what she has the readiness to address. So I think recognizing that there are multiple perpetrators, that could simultaneously to those resources like the EEOC. And Bill will talk later about how advocate can play a role in the actual complaint process. Those of you that filled out the survey said that you wanted to know, how do you actually access the remedy? What's the procedural steps? And then thinking about your role throughout the complaint process, I think it's really important. And then sort of the bigger picture thing of, these are the different ways that we can sort of break down the silos. I know that I was always putting things in compartments like, oh, the EEOC, that's civil rights, sexual assault, that's rape, that's a crime, domestic violence, that's gender violence, without recognizing all of those intersections. And I think the best way to really look at that and to try to think about how we can organize so that we can frame things with more intersectionality and in a way that really makes sense to the women in the communities that we work with is on the next slide, which is something that many of you may have seen. Is Lifetime Spiral. It's sort of the approach that we use with the Asian Pacific Islander Institute on Domestic Violence, looking at all the kinds of gender violence that may occur from infant, baby time to when you're an adult, and then to your elderly years, and thinking about how some of these forms of violence and oppression are occurring simultaneously. And so many of this in the spiral can happen in a workplace setting. And we know that in the communities in which we work, we are working with women who are in dangerous zones, like, for example, in the agricultural industry, in the possibly the restaurant business, in the hotel industry, etc., where there is an incredible amount of hierarchy and power, just like in the intimate partner relationship. We'll see a lot of sexual violence, and I think both Bill and I agree that it's so pervasive, so much more pervasive than we're able to address formally. So that's just really the framing piece, and I'm going to turn it over to Bill now to tell you about the EEOC remedies that you can access for your clients and the women that you work with.
Okay, I hope you can hear me.
Yes, I can hear you, Bill.
Okay, this is Bill. Can you hear me? Hello?
Hi, yes, Bill, we can hear you.
Yeah, okay, thanks. Can you pop up my slides?
Okay, let's see. Are you able to move your slides, Bill?
It's not even on here.
Oh, it's not? Oh, I'm sorry about that. Okay.
Okay, thank you. Good morning or good afternoon to everybody wherever you are. My name's Bill Tamayo. I'm the okay, this is a different thing that just popped up here, Nancy. Okay.
What popped up there?
My slideshow's not up. Okay, here we go. Okay, so I'm the regional attorney for the United States Equal Employment Opportunity Commission, which is the federal agency charged with investigating allegations of discrimination, including sexual harassment, and if we need to, we'll sue employers. Someone's moving my slides, is it?
Oh, sorry. Sorry, I thought I was in the chat.
Okay, so let me start all over. Okay, so I head up the Equal Employment Opportunity Commission here in San Francisco, and we're the agency that can investigate claims of discrimination, including sexual harassment. and then we could file lawsuits. My office has filed several sexual. Somebody's moving my slides, is it? Okay, so we've been able to file a lot of sexual harassment cases on behalf of immigrant women in particular, and most of these have included violent acts or rapes. And my jurisdiction is stated on the slide. My introduction, though, to dealing with violence against women was as a staff attorney at the Asian Law Caucus here in San Francisco, where I represented close to 4 dozen battered immigrant women referred to me by the Asian Women's Shelter. And at that time, I used to practice a lot of immigration law, and I was faced with that situation where battered women were being threatened with deportation by their husbands, petitions being withdrawn, all these kinds of things if the women complained to the police. So I was the lead author on the memo for Congress that led to the self-petitioning provisions of VAWA, so that we were able to remove immigration status as a weapon in the arsenal of the perpetrator. Then I shifted to the EEOC to enforce these civil rights laws. And so I'm talking to you as somebody who's been able to kind of learn it from both sides, the domestic violence side and also from the civil rights employment discrimination side. But the commonality we have with domestic violence, sexual assault in the workplace, and including military sexual assault, is it's all about power. It's all about violence. The difference here is, at least in domestic violence cases, we target the abusers and criminal justice system and try to get remedies through there, but basically get the guy locked up and make sure that the victim is in a safe place. In sexual harassment, what we try to do is target the company for money, make them pay so that they can make Maria whole, and then give her back pay that she may have lost, compensate her for her pain and suffering, and maybe provide her money because their behavior was would merit punitive damages. So we also try to change the workplace. So in domestic violence, we say the balance of power is the spouse versus spouse. The husband has the job, money, controls, maybe he's the one who speaks English, but the remedies are fairly limited. In non-work related sexual assault, usually it's by a stranger, there's different issues there. There's no real money against the individual. There's some kind of lawsuit filed against him, and usually he has no money. In the employment situation, it's like the military, like at home, it's all about power. So what I want the attendees to really understand is, from my view, I think the imbalance of power at the workplace is one of the greatest that actually allows a predator to perform or to commit these sexual assaults against the women. So it's really not so much Maria versus Joe, it's now Maria versus the company. And the perpetrator knows this, because the perpetrator knows that she needs a job, she's got limited education, and then the company has all the resources to fight Maria off. And the predator knows that he can control whether she eats, whether she has a roof over her head. He knows he can fire her siblings who work for the company. All of these are weapons in the arsenal of the predator. So not only does he have this personal power, he has the company's connections, the lawyers behind him. So what do we try to get? What we try to get for them is money. That's what the law provides for. You can get money for if you've been fired or denied a promotion, you get back pay. You can get reinstatement to your job. We will get money for emotional distress, pain and suffering, and then punitive damages to punish the company. People who were witnesses in the case and who were retaliated against, we may be able to get money for them too, because their civil rights have been violated. There is a cap on damages outside of back pay, which is $300,000 per employee. Sometimes we've been able to get the harasser fired or barred from future hiring, and then get the company to actually adopt new policies around sexual harassment. So I want to give some historical context, which is sexual harassment has not always been illegal. It was not recognized sex discrimination wasn't prohibited in law until 1965 after the Civil Rights Act went into effect, and the Supreme Court never recognized sexual harassment as a civil rights violation until 1986. So it's still a relatively recent phenomenon. And then part of Title VII was to create the EEOC to investigate these types of cases. So, most countries don't have anti-sexual harassment laws. And they don't provide many remedies at all. The United States experience is still pretty unique in the world. However, we have been getting more and more sexual harassment complaints over the years. They are now 12% of the charges that we receive nationwide. In my office, although they're still about 12 to 15% of the charges, it's about 30 to 35% of the cases we actually litigate in court, in part because we have large agricultural industries and a service industry. So let's get into what the law really is on this. Okay, so the victims can be male or female. The harassers can be male or female. The harasser can be a supervisor, an agent of the employer, a co-worker, or even a third party. So what do I mean by a third party? So if there's a vendor who comes into the company's premises and is sexually harassing an employee of the company, the employer has a duty to make sure it's safe and could be liable for the harassment by the third party. And so that's got to be clear. It's not always have to be a co-employee or an immediate supervisor. It could be a third party. A victim can also be somebody who's not directly targeted, but nevertheless is in the vicinity of the hostile work environment where women are being called all kinds of names, there's offensive behavior going on, and she sees it every day and it's part of her work condition. She may be affected and she might be a victim. So what is sexual harassment? It includes everything from verbal comments, proposals for sex, certain demeaning statements being made to women, but it usually can go all the way up to rape, actual assaults on the women. So most of the times, if it's just verbal things, women aren't complaining, particularly if it's in a service setting or in a work or in an agricultural setting. But once it gets into the physical realm, many times that will motivate, or at least sometimes that will motivate the women to start complaining. What the courts say, though, is that the behavior has to be so severe or pervasive enough to alter an employee's working conditions that it creates a hostile work environment. And the view is that of a reasonable woman who placed in that situation would think that these conditions are bad and it's changing her work. She didn't come to work expecting to be sexually harassed. She came to work to do her job and then get paid for that. But once it becomes such that it's difficult for her to do her job, that is changing her conditions, then you might have a violation. So people say, well, what about, there's some sexual banter in the office? It really depends on the conditions there and what's from her as a reasonable woman, and if she subjectively believes that this is a hostile work environment, that may be all we need to prove. The other part, so sexual harassment can include what's called quid pro quo. Under federal law, this means, if somebody says, look, Maria, you want to get a promotion? This is what you need to do. Or like in one of our first farm worker cases, where a farm worker was told, well, Blanca, if you want to pick up fruits this season, you got to do what all the other girls do. And she knew that she had to go with him to the motel in Yuma, Arizona, and then later on in the year she had to go to his house to have sex with him in Salinas, California, so that she could be hired to pick crops for that part of the season. The law says if an employer requires makes sex a requirement for job conditions, that's illegal, and there is no employer defense to that. It's called a tangible employment action. or she's fired right after she complains. That could be a tangible employment action. Then when there's harassment by a supervisor, an employer can be liable, but it could escape liability through what's called the affirmative defense if it shows that once it heard about that it took steps to deter the harassment, and once they knew about it, they took prompt and corrective action, which could mean they have to investigate, and maybe they have to terminate the guy or suspend the guy, and they have to show that Maria failed to notify the employer or use the company's preventive measures. In many of these cases, there is no place for the woman to complain, or she knows that Susie complained the other month and she was fired. And we tell employers then, well, then you don't have a mechanism for her to complain because it's meaningless, and therefore they can't show the second part of their affirmative defense, and the employer could be liable. In California and many other states, under state law, a company is strictly liable for supervisor harassment. They have no defense. So it's important to find out when you interview Maria who is doing this and what's his position in the company. Now, the company can also be liable for harassment by a non-supervisor. So as I mentioned earlier, this can include coworkers or non-parties. If this occurs, Maria has to show that the employer knew or should have known about the harassment, and once it knew, it failed to take prompt and corrective action to deter the harassment or to deter future conduct. And the key case on this, it's not in my materials, is a case called Fuller versus City of Oakland, where Fuller was a police officer who was dating Officer Romero. They have a 9-month relationship. She cuts it off. Romero doesn't get it, and he still continues to harass her and badger her. And ultimately, she complains to the police department. Police department does nothing about it, but eventually the harassment stopped. So when she takes her case to trial, the lower court says, sorry, the harassment has stopped. There's no more basis for your claim. Fortunately, she appealed the case, and the Court of Appeal says, no, 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 the employer's duty not only requires stopping the harassment, but they have to deter future harassment. And in that case, she wasn't convinced it was a safe place. Romero had been promoted to captain, was never disciplined, and then one of the witnesses in her hearings was also retaliated against, and she said, this is not going to stop future harassment. The City of Oakland ended up paying close to $500,000 to Fuller and to her co-officer who testified on her behalf. So, let's say a charge is filed with the EEOC. How do we investigate it? What are we looking for? We're going to ask pretty much common questions. How did it occur? Did she ever complain? And did the employee fail to protect the employee from harassment? Meaning, did she complain and then they still didn't do anything and the harassment continued? We'll want to know who is the harasser. Is it somebody so high in the company that there's nowhere for her to complain? And then most importantly, you'll want to know, and we will want to know, after she complained, was she threatened, by the harasser, or did the employer say, Maria, Joe hired you, why don't you just drop this if you want to keep working here? Or did they threaten her so that she would not complain? All of that is relevant information that we're going to need. So people say, well, how do you prove this? Most of the harassment happens behind closed doors. There's no third-party witness. There's no, camera that's there to record what's going on. Well, in most sexual assault and rape cases, there are no witnesses except the two people who are involved in the incident, but somehow police and prosecutors are able to prove their cases. So they do it by taking all kinds of evidence, and we will do the same thing too. So the first issue we want to find out is, do we believe Maria's story? Okay, so we've trained our investigators to say, don't assume that the charging party, CP, is lying, because we have to listen to her story. Is she emotionally upset when she comes in? That might support her. If she's not upset when she tells the story, that's inconclusive, because we know when women are sexually assaulted, there's no one way for them to react. So we can't make any conclusions if she's stoic, if she tells her story calmly. If she's crying, that helps buttress her case. If she doesn't cry, inconclusive about her credibility. Can she describe what happened in detail? So this is a critical part. You know, we had cases where sometimes the farm workers would say, well, what happened? She goes, oh, I fulfilled my obligation. Meaning I went and had sex with the guy in order to get a job. But it was hard for her to describe what actually happened, and so to test her credibility, we asked her to go explain step by step what happened. Where did he touch you? How often? Where did he put his hands? Because sometimes that will help to buttress her credibility. On the other hand, we have to confront the dynamic that sometimes women can cope or at least try to survive egregious sexual assault by blocking out the details. But it's the kind of recollection we're going to need her to do, and if she ever went to court, she would have to be able to state to the jury, this is what happened. With verbal harassment, same thing. We want to know what comments were said, frequency, etc. And then again, were there any threats by the harasser? Like we've had cases like Willamette Tree, where after he raped her, he says, if you tell anybody, I'm going to kill you and your siblings who work here at the farm. Or in our case against Harris Farms, where Rene Rodriguez tells Olivia, after he rapes her, if you tell anybody, I am going to kill your husband. So all of those things come into play, because if there were threats like that, maybe that's why she didn't complain to Human Resources. Maybe that's why she didn't talk to anybody. All of those go to the issue of her credibility. Other things we will look at, if there were physical injuries, if she went to seek medical treatment, which is very unlikely in most of these cases. We're talking about immigrant women who may not have any kind of health care coverage, have no place to go, no culturally competent medical staff in their area. You know, if they have medical help or they have psychological treatment, all that can help us. Remember, every little thing is used to establish liability and damages. We need that all to establish her credibility. In Tanamura and Antle, this was a case where a farm worker was forced to have sex with a hiring official in order to get a job picking crops. We were able to verify her story by asking her what happened in detail. And she says, well, the first time he said I had to go in his truck, and we went to the motel in Yuma, Arizona. He first went to the bank, got cash, then he went to the motel. So we had our investigator go to the bank. Sure enough, there was a withdrawal that day for $60. And then we went to the hotel, and there was verification that he was at the hotel that day. So at least those are two pieces of evidence that corroborate her. Then when she came up to Salinas, we said, so then what happened in Salinas? Well, he told me that I had to go to his house. My friend dropped me off at his house. And the friend corroborated that. And I wish we were live because I can't really show you what happened there was we asked her how, our question is, how do we show that it was non-consensual, that she was not doing this willingly, that she did not consent to this? And I said, why don't we have her just draw the layout of the perpetrator's house? And she did, and she drew a layout, and she said, here was the kitchen, here was the living room, here was the dining room, here was the television where my 3-year-old daughter was watching TV, and here's the bedroom, and she broke down and cried. That was enough for us to show that something traumatic happened that day. This was not some kind of consensual affair. that was going on. Because if it's a consensual affair, you don't bring your 3-year-old daughter to that house. So there we believe that she was credible. We eventually, made findings, and we settled that case for $1.855 million. So how do we know whether he's credible or not? So we always want to ask, who supports his story? We want that if he can only say 2 things, right? 1, it was a consensual affair, or 2, it never happened. So those are the only 2 ways that he can go. So we're going to try to probe that angle more. And then we'll also want to know, has he ever had any record of prior complaints of sexual harassment? During our investigation, we'll be able to get his personnel file and all the records of any previous complaints. Corroboration, if she told coworkers, supervisors, we'll try to interview them. If she went to the doctor, again, hopefully that can support us. If she told any of her family about what's going on, that could help. And then if she knows of anybody else who's been harassed, did the charging complain to them? Do we know about any other evidence? Anything could support her credibility here. We have to just be creative on that. Proving harassment. We're continuing this, so I want to use this example of a case where a mother shows up at her house and she sees her teenage daughter curled up in a fetal position on the couch. The daughter's crying, and the mother knows something's wrong, and that she fortunately got the teen to talk, and the teen complained that at the shoe store where she was working, her assistant manager had constantly been propositioning her for sex, and that when she complained, he threatened to break her neck. And after she complained the second time, he literally put his hands around her neck and was about to choke her. That's the case. But what got us to corroborate it is the mother gave her observations to us, and we said, she's telling us true story here. We settled that case with like $125,000 or $135,000 about over 10 years ago. The woman is Tiffany Grable, and she continues to do sexual harassment education for us. Was a police report filed? We know that in less than 10% of the cases, sexual assault crimes are not reported, so it's not a big deal for us. And in EEOC versus Harris Farms, this actually was reported to the deputy sheriff. Deputy sheriff didn't believe her, said the victim is lying. But the jury believed her and awarded nearly $1 million to the victim in our employment discrimination case. Okay, so as you know, there are going to be many hurdles in proving harassment, which may include, she's afraid to tell her family, she's going to be stigmatized. There's peer pressure on her not to tell anybody about it. People need the job to support the family. Other coworkers may not want her to complain because the hiring official, who's also the perpetrator, hired them and they want their relatives hired. All of these things will come into play, including threats of harm, immigration status, etc. But our goal is to try to minimize all of those factors so that she can tell her story. That's all we're trying to do to get there. One of the more common things we see is she's afraid to report it because she thinks her spouse or boyfriend won't believe her and may beat her up or may go kill the perpetrator. So those are the things that come forward during our investigation, but what we try to know is that just because she doesn't tell somebody right away, that doesn't mean she's lying. In nearly all of these cases, there's threats of retaliation or, threats of termination or retaliation may chill her out, my mistake. So why don't we stop there and just see what questions there might be. And Nancy, how do you want to handle this one?
Well, thank you, Bill. Thank you for all that information. From the chat, it seems like some people had some questions about specifics like, is there the phrasing of statute of limitations for filing sexual harassment cases?
I'll get to the statute of limitations later.
Okay. And Bill, there is sort of a number of people who are asking about how do they get in contact with their local EEOC office. Do you want to cover that later about how do you figure out,
that will be all later on, and it's in my slideshow, all the contact information.
Yeah, and you'll all get this material afterwards. Bill, there was also a question about what if your supervisor is actually a group of people, like for example, currently right now, maybe you're without a director, and so currently your supervisor is the entire board. I mean, you have any, and so the specific question was, how do you, tell your supervisor without the entire board knowing, or do you have any, I don't know if you've ever had that dilemma or faced a case like that, but do you have any thoughts for this participant?
Where the supervisor of the employee is an entire board?
Yes.
There has to be a board chair or officer.
I guess the query is the confidentiality and, that the president of the board may feel they need to share that with the entire board. And that puts the
That's a good question, because what we advise employers is the information can be shared with the people who need to know. So for example, Maria goes to Human Resources and tells them that Joe's been harassing her supervisor. It's okay for HR to notify the director that there's a complaint against Joe. The assurance, because what they're also trying to do is make sure that they don't do anything that looks like retaliation against Maria for complaining. And if they start to breach the confidentiality and get it out there to everybody in the world, it can end up being retaliation because it's intended to chill her out.
Right.
So the smart companies will just only tell those who need to know. Mm-hmm. It shouldn't get out publicly. And any place where generally you don't report to a whole board, there has to be an executive, a CEO or a board president who ultimately gets charged by law as an officer for making those decisions.
But Bill, you bring up another really good point, which often happens in many cases, which is, that based on who may know what's going on and who they're aligned with, if they're aligned with the perpetrator, the kinds of, chilling out, the kinds of intimidation, even getting out other witnesses. Have you had a lot of cases where maybe the survivor doesn't have a lot of evidence to support the actual sexual violence, sexual harassment, but where there has been a finding or she won on the retaliation because there was more proof of the retaliation?
Yeah, that happens in a lot of discrimination cases where the jury just doesn't believe the actual discrimination occurred, but they believe that she was retaliated against for complaining when they just fired her. So that's pretty common.
Okay. Nancy, did you have any other questions from chat for now?
No, not at the moment.
I think we can move on, Bill, because you're covering the other questions that were posed in later slides.
That's a good segue to the next slide, which is on retaliation. So retaliation is a separate violation of the civil rights law. So there's the sexual harassment side, and then there's the retaliation. Because employees have the right to complain about a violation if they reasonably think a violation's occurred. For us at the EEOC, what's really stark is that retaliation used to follow race claims as the highest number of charges filed, but in 2011 and in 2012, retaliation became the primary form or the leading form of discrimination that people complained about. And here in California, it's nearly half of the charges we get have a retaliation claim. Interestingly, in all the sexual harassment lawsuits that the EEOC has filed, there's always a companion retaliation claim, which generally means that Maria was told, if you complain about this, we're going to fire you, or she did complain and they fired her, or they demoted her, or they reduced her hours, something like that. Because the whole purpose of retaliation is, does it try to discourage a reasonable employee, discourage her from filing a claim? So what the courts look at is, was there an adverse action? Did that action serve to discourage or try to discourage her from pursuing her complaint. So the way it breaks down legally is a protected activity. It's, you have the right to complain about what you reasonably believe is unlawful discrimination. So this can be from complaining, saying I'm going to file a charge, refusing to obey a discriminatory order, or refusing sexual advances. So if the supervisor goes up to Maria and says, Maria, I would like to go out with you tonight and we could have a really good time. We go into the motel, or maybe you should go with me to this on this trip, overnight trip, and I think we could have a good time and wear your slinky dress and all this kind of stuff. And she says, no, I'm not going to do that. That might be refusal to engage in sexual activity. The issue comes up is you just have to show some kind of opposition. So in Crawford versus Metropolitan Authority, the Supreme Court case, Ms. Crawford was a 30-year employee for City of Nashville, and she was brought into an investigation and told that there are some rumors that one of the department managers was harassing women, and did she know anything about it? And she proceeded to describe the kind of acts that this guy did, which was like showing his erection through his pants to women going up to the window pane, from the hallway to their office, grabbing them, touching about and talking about his sexual activities and so forth. And the issue before the court was she didn't oppose this. She didn't actually oppose this. She's not the one who went to Human Resources to complain. She was just cooperating in an investigation that was launched by the city. And the Supreme Court says, look, when she was describing these despicable acts by this manager, that was showing her opposition to sexual harassment, and that's enough to qualify as protected activity. I should tell you, the person who was charged with sexual harassment was the head of employee relations for the city. In Fry's Electronics, this is a case that my office brought in Seattle. America Rios complains that she's receiving sexting messages from her assistant store manager, reports this to Mr. Lam, who's a Chinese-American supervisor. He reports this to the higher-ups, and within 2 weeks, he's fired. And they had also, the company during the litigation destroyed records of prior sexual harassment complaints against the store. The store manager. We settled that case for $2.3 million. 1.6 went to Mr. Lam, who was fired, and $700,000 went to Ms. Rios, who was sexually harassed. We also got the court to sanction Fry's for destroying records that they clearly had in their possession before the litigation started. National Food Corporation, this is a case where unfortunately a woman was forced to perform oral sex on the supervisor in the egg farm in the barn for 7 years, and she was fired. And then 4 employees who complained about sexual harassment going on the farm were also fired, and we settled that case earlier this year for $650,000. So retaliation plays a key part. The
Conferencing Center. Please enter your passcode followed by the pound sign.
By pressing *6. When you hear the tone, you will be the 29th person to join the meeting.
Some people can't, so.
Yeah, going back to the issue, this was in the previous set. Well, I guess in terms of retaliation, I was chatting with folks publicly about. I have a lot of cases that have retaliation, and I think you might have told me that Hawaii is like one of the most retaliatory states. Or we have, in terms of our state civil rights commission, we've had like such incredibly high numbers every year for the last 10 years. And I'm just thinking, how can we be more proactive about this as domestic violence and sexual assault advocates in the way that we do risk assessment and lethality assessment? You know, thinking about all of these external harms and vulnerabilities for the women that we work with, anticipating that this is likely going to happen in terms of her physical safety and also, you know, her emotional well-being. I mean, I would think that we would want to try to, before she even files, obviously think about these things and weigh all of that, but also identify specifically like who would be possibly doing the retaliation and what might the retaliation look like. Because obviously, I mean, you know, so many survivors, they know their perpetrators. Do you have any thoughts about that? As far as the safety issues, or, you know, and obviously that this is where the advocate can play a key role even throughout the complaint process and the investigation.
Well, I will talk about the cases where we've had to go into court where they were basically threatened with death if they filed their charges, and so, or further harassment. And so I can get into that later on, but I think what we want to do, as she knows there's a risk already everywhere.
Right.
What we're trying to do is at least inform her of the risk, but minimize it. So we also know some women have not complained because they can't afford to be fired. But sometimes what gets them over the hump to actually come in is they go, I don't want this to happen to another employee.
Mm-hmm.
Or like in Harris Farm, she doesn't complain for 6 years because the perpetrator said, if you tell anybody, I'm going to kill your husband. But he constantly harasses her, and she finally, the straw breaks the camel's back. She goes to a rape crisis center, and she tells them what's going on at work, and the rape crisis center gets the case to the EEOC.
Right. Sometimes
there's something along the way that gets them to finally get the moxie. It's no different from somebody who's a domestic violence victim, right? Somewhere along the line, hopefully she'll get the courage, and she comes forward to complain. As advocates, you can tell her that this may be a possibility, but importantly, retaliation is illegal. So if the company fires her, that's another violation that we could go after the company for.
Okay, so important.
I'll talk about that later on in the outline.
So just one last thing, Bill, before you move on to your next set of slides. You raised a really two important points. One about sort of the deep domestic violence sex assault overlap. It becomes even doubly a barrier, right? If at the time where the domestic violence advocate is working with the survivor to sort of be liberated from the abusive relationship, and one issue is the economic dependence on the, or at least the contribution by the spouse or the partner, and then having to contemplate, also leaving your job, right? So, looking at sort of economic self-sufficiency, et cetera, as a way to sort of try to help relieve that barrier, because it may be that you can't leave your job because, and yet the what's happening at the workplace feels more traumatizing and more dangerous so those are, I think, really, really difficult dilemmas. But I think you're right that you have to look at it in the same way and sort of implement some of the same strategies as you would in the domestic violence context. And then I think we should move on to your next set of slides.
Okay, so let me just get back to the procedures then. So anybody can file, is covered by these laws, so long they work at a place that has 15 or more employees. Okay, so, and that's something that we'll investigate. You just come forward, file it, and then we'll do the investigation about whether there's 15 or more employees. Sometimes there's joint employers, particularly in agriculture, where there's a labor contractor, and then there's the farm, or in janitorial, that may come up too.
Oh, Bill, I just wanted to interject for a moment. If we can, can you hear me?
Yeah.
Yes. We did have a question about employers that have less than 15 employees. Maybe we can come back at the last break.
Okay. Well, you can ask that now. I'm on the question.
Oh, sure. Yes. So what are some things that can be done for employers that have less than 15 employees?
Well, some state laws like California, you just got to have 4 or more employees Hawaii and in California for sexual harassment, you can only have, if you just have one employee, you're covered. Hawaii, I can't remember now Hawaii's law, Jen, on how many employees you got to have in Hawaii. In Washington State, it's like 8 employees. So at least you have to check what the adequate state law is. But sometimes the employees themselves don't know. So they can still come forward to the EEOC, file a charge, and Maria says, I think there's 15 or more employees, but I don't know. But we will do the investigation to find out whether we have jurisdiction on that. And if they don't, then the case will be sent over to the State Fair Employment and Practices Agency to investigate.
I see. Thank you.
So on immigration status issues, we will not ask immigration status. I litigated the case that says undocumented workers are covered by Title VII. So don't worry about that, at least at this stage. And then the law covers people, citizens working abroad for U.S. companies. It can include third parties, can come forward to file a charge. A commissioner, one of the commissioners can say, look, I heard there's discrimination going on at X and X company. I think the San Francisco EEOC office needs to investigate this. We have 5 commissioners in Washington, D.C. Any of them can do this. Just remember, in order for somebody to get into federal court on an employment discrimination case, they have to file a charge with the EEOC or one of the Fair Employment Practices agencies. At least in Washington State, that is not a requirement to go to state court. But when I say it's a prerequisite, you need to make sure she comes to the EEOC in order to pursue her rights. It's not the role of the advocate to decide whether this case should be at the EEOC. You tell her the EEOC is a place that handles employment discrimination. You should go there. And then you let the EEOC determine whether she's at the right place or not. Okay? I just really want to stress that because sometimes advocates say, well, I don't know whether she should go there or not. That's not your role. All you know is she alleged sexual harassment. It's covered by EEOC statutes. Tell her to go there. Timeliness. So generally the federal law says you have to file it within 180 days of the discriminatory act. But there is a special provision that says if you're in a jurisdiction that also has a Fair Employment Practices Agency, like the Hawaii Civil Rights Commission, the Washington Human Rights Commission, California's Fair Employment and Department of Fair Employment and Housing, then you have 300 days to file a charge with the EEOC. So 300 days seems like a lot of time, but remember, we're dealing with women who have tried to deal with sexual assault by repressing it, or they're too scared to tell anybody, or they don't have any place to go to. So this timing is very important. If you're terminated, if you're told you're being fired, the clock starts ticking on the day you're being told, not on your last day of work. And in harassment cases, if you have what's called a continuing pattern of harassment, so it's been going on for months or years, way past 300 days, so long the last incident occurs within the last 300 days, she's covered. In EEOC versus Harris Farm, she was raped in 93, 94, and 95. He constantly badgered her, threatened her, all the way until 1999. And we allege in our lawsuit that we are trying to get remedies for the first rapes back till 93 and 94, 95. And we would have, the company didn't object to that one, but we would have argued that it was a continuing violation by the perpetrator over a number of years. Timeliness. Okay, so I want to get back into the timeliness. So in Willamette Tree, Emeteria had not told anybody that she had been raped for over a year. Her sister, Flora, goes to Oregon Law Center because she had just been fired after she protested sexual harassment. Oregon Law Center lawyers say, do you know if there's anybody else? And Flora says, yes, my sister Emmy hasn't been the same since she was fired over a year ago. So they said, bring her in. And then Emmy tells a story that on her first day of work, she was brought to a room on the farm where there are all these flattened cardboard boxes. The supervisor throws her down, puts gardening shears to her throat, and proceeds to rape her, and tells her if she reports it to anybody, he will kill her, her kids in Mexico, and her siblings who work at the farm. And then over a course of 3 months in wintertime, he dragged her out to the fields and forced her to perform oral sex on him at least about a dozen times. And then when she could not perform it anymore because her throat was damaged, he fired her. So that's the case. Our calculations were she had missed the deadline by 62 days. How could she pursue her case? So my directions to our office up in Seattle was, you take this charge, you let her file it, and we will argue equitable tolling. And equitable tolling says the court can allow a late filing if there are conditions that prevented the employee from complaining. And the key case is Stoll versus Runyon, a case where a postal worker was raped repeatedly by her supervisors, and they beat her up, and she was so traumatized that she could not file her lawsuit on time, even though she had a lawyer, because she couldn't cooperate with her lawyer in order to get all the facts out because she was so traumatized. Fortunately, in the Willamette Tree case, the judge bought the argument and said that the company cannot benefit from Emeteria having been traumatized by the repeated rapes and threats to kill her husband. There we had a therapist and a psychologist work with Emeteria, and it was their reports and testimony that allowed us to pursue this lawsuit way after the deadline. So this is critical, okay? So if you think, oh, she's missed it by 300 days, that's not the end of the story. There may be reasons why she didn't come to your office, to your agency, within 300 days. So, and that's the fact that there's going to be threats is not uncommon, okay? So after a charge is filed, the company receives a copy of the charge in 10 days. They get an opportunity to give their version of the case. We ask for all kinds of information. We want to interview witnesses. Sometimes we'll visit the facility, look at documents. I want to tell you now, anything that you say with the investigator are not necessarily confidential, privileged communications. The whole investigation, we don't talk about it to anybody except those who are affected. But if there is a lawsuit in litigation, all of these things that the claimant says to the investigator might be disclosed. So just know that. And then if you want more, I have a whole outline just on this whole issue on privilege and confidentiality. But if we are in a lawsuit and the EEOC is filing on behalf of the charging party, we share the confidential attorney-client privilege. Okay, so just make sure Maria should not go in saying my husband's here illegally, I'm here illegally, all that kind of stuff. Don't say that to the investigator, although we've told investigators that's irrelevant. It's like she told you she had eggs for breakfast. She doesn't need to talk about it. So the question was, suppose you have all these threats, and it's going to prevent the charging party from being a witness in the investigation. So the government, EEOC, can go into federal court to get a temporary restraining order to maintain the status quo. So it basically is to prevent people from being intimidated, from being threatened, from being fired, and we can just get that kind of thing. That happened in EEOC versus DeCoster Farms, where women had been raped multiple times. Word gets out that the EEOC is going to come down, send some investigators, and then the supervisors threaten the women that if they cooperate with the EEOC, they'll be fired, deported, or further harassed. And we had to go to federal court to seek a temporary restraining order, and the company backed off. That case settled for $1.5 million. In investigations, we can investigate the employer's records. They're supposed to cooperate with us. If they don't cooperate, then we get a subpoena, and 99% of the time the court will tell them to turn over all the information. We may want to also find out whether there's other victims and witnesses. So this is important. Are there other victims? Because even though we only have Maria's charge, but if Maria says, well, I'm not the only one, I think Susie, Barbara, Letitia, and others have been sexually harassed by Joe, the EEOC can go in and ask information about those women and can go ahead and interview them and get money for them if we can find out about them during the investigation. So it's important to find out from her is, does she believe that other individuals have been victims of harassment or discrimination? Because then they're also able to get some relief. So resolving charges. It may be that we decide there's not enough evidence to support the violation, the allegation, and we'll say that. And then Maria will get a notice of right to sue, which allows her to go to federal court, but she only has 90 days to file the lawsuit. Then I mentioned the equitable tolling of Stoll versus Runyon. There she missed her deadline. She filed her case on, I think it was like 105 days past. She was supposed to file it in 90, and she filed it in 105 days, and the Court of Appeals granted her equitable tolling. So let's say she gets a finding from the EEOC that says reasonable cause to believe that a violation's occurred. We will get the parties together. EEOC will make a demand and say, we want X and X amount of money from Maria. We want to have the supervisor fired, and we want to give her all her back pay and get her reinstated. Company can come back and say, well, we're not going to give you $250,000, but here's $25,000, but we don't want her back. Little give and take, but if it's clear to us that it's not going anywhere, we will fail the conciliation. Then the matter comes to me as the regional attorney, and then I decide whether we should file a lawsuit on Maria's behalf. So the lawsuit then is United States government through the Equal Employment Opportunity Commission versus X company, but we're suing on behalf of Maria. So the dynamic, it's not Maria versus X company, it's United States government versus X company, which puts her case, I think, in a better posture than her individually taking it on. Employers will look at it quite differently if they find it's the government as opposed to an individual plaintiff filing the lawsuit. And then again, if there's other victims that we find during the investigation or during the litigation, we can get relief for them. If the company wants to settle, the settlement authority rests with the regional attorney, who's me in San Francisco, and I'm going to decide is whether this is going to be enough money to compensate Maria and the other victims. If we file a lawsuit, Maria also has a right to join the lawsuit and bring in related state claims or just join the general lawsuit, and she's another party in the litigation. Obviously, some of the things we're going to deal with, I'm sure most of you have dealt with it, is with victims have to describe some very sensitive stuff. It's best for them to describe it in their first language. So we know that a lot of women will have a difficult time describing sexual assault in graphic terms, but they'll do it better if they speak in their first language. So it's trying to make sure someone there who's at your office to meet with her is competent to get the information out. We all know about the fears of immigrant workers. I don't have to get into it. If you want to see something about some of the cases that my office has done on behalf of farm workers and other offices have done, see the PBS documentary Rape in the Fields. It just came out in June. You can easily access it and watch it online. I'm just going to briefly talk. These are some of the cases we've done where we've recovered money for workers. I mentioned some of them. Harris Farms was $1 million. We ended up with $1 million. Same thing in Rivera Vineyards. Wilcox Farms, the case out of Oregon, we got $260,000 for a worker whose supervisor put his hands down her panties and repeatedly propositioned her for sex and groped her. ABM was a case our LA office did where 21 Latina janitors were ongoing sexual harassment. One of them had been raped. We settled that case for $5.8 million. If you go to our website, eeoc.gov, we have all kinds of resources and the list of all the regional attorneys around the country, and you can easily access that. So why don't we go to the final questions here.
Great, Bill. Wow, that's so much information. And for all of you, Bill really does this as a 2-hour piece, so we forced him to really condense to some essential points. But I'll just lift out a few, Bill. So just to reiterate some of the really important points you were making about filing. So from the advocate's perspective, advocates should still encourage the survivor, if she's already deciding that she wants to file a complaint, to not worry about whether or not we know about whether there's 15 employees or not, or whether or not they met the 300 days or the 180 days, right? Would you encourage the person to go ahead and submit their complaint?
Yeah, that's right, because even if we may not have jurisdiction, the state agency might, and we will accept the charge for the state agency. Great
segue, Bill. So for just to reiterate to everybody out there that Bill's office, the EEOC or your local EEOC office, will know if it's not their jurisdiction to refer it out to the state equivalent agency. Can you just speak really briefly about the state equivalent agency, Bill, and how you guys are different?
Well, sometimes the state agencies have other remedies, and one of the important things is federal law caps damages, that's pain and suffering and punitive damages, at $300,000, depending on the size of the company. Whereas in like Hawaii, California, Washington State, there's no cap on damages. And we know that $300,000 in this day and age is not that much money if she's been raped repeatedly. And so you can get uncapped damages there.
So, Bill, the question about how it keeps coming up about how to connect with your local office. I mean, is it on the EEOC website that you can figure out?
Yeah, they look for it is on the EEOC website how to contact us, and it will list the regional attorney for that area. So I encourage you to contact that regional attorney, tell them that you heard of my training and that you'd like to meet and find out how you can collaborate. Because what we and other offices have been doing this. What we've done is collaborate with various, sexual assault programs, farm worker programs, so that we can get the word out and do more training.
So, Bill, you just to go back to my story, when I was doing domestic violence work way back when, Bill really encouraged me to connect even before I was able to identify that I had any clients or communities that were dealing with workplace sexual violence, to connect with the local office here in Honolulu. So just to even have that collaborative connection. So over here in Honolulu, it's Tim Riera. I know some Hawaii people are on the call, and what we started to do is Tim and I started collaborating on different issues, and even though I'm on campus, we would have cross-training. And I think the community really found it helpful. So I think those of you who are already chatting about how you want to follow up, it's so exciting that you want to do something to follow up on Bill's training, something locally.
Let me add, I really want to thank all of you for participating on this, because you're doing that frontline work. And if you have any questions, don't hesitate to call me, okay? Err on the side of calling me. If somebody says, oh, Bill's too busy, err on the side of calling me. Let me make the determination whether I have time to talk with you. I most likely will want to talk to you all the time, because these are critical issues that come up. These are life and death matters. And I know most of my colleagues would also be available to talk to you right away if you have a crisis going on. So don't hesitate to call.
Bill, that's very, you are a very busy person. That's so generous of you. And I just want to say that Bill is being completely sincere because I call him all the time. And he's actually been a mentor for me. And he understands the immigrant issues. He understands the cultural issues. He understands the power and control, domestic violence issues, because even though he's representing the federal government, he has done much work before he became a Fed. And in his community work, he's done a lot of advocacy work for the battered immigrant women's community. As he mentioned, he was one of the first authors of the VAWA immigrant provision. So I really encourage, I've learned a lot from him, and it's helped me to sort of shape, how I do my own training. So I want to thank all of you for actually taking that on, willing to take that on and engaging in your communities. It's exciting.
Just add too, for the EEOC nationwide, last year they set up for 5 years what are the strategic enforcement plan. And we listed out our priorities. And one of the top 6 priorities is addressing the issues of migrant women, farm workers, and immigrant women, and in particular around sexual harassment. So other offices around the country know that this is a priority. And offices in Atlanta, Miami, Birmingham, Texas, all of them are doing something around immigrant workers. Chicago, New York, they've done a lot around undocumented workers, immigrant workers. So this is not like some new issue for them to hear about. They know about it. We have a track record, and they'll be more than happy to talk to you.
And Bill, before we make some closing comments, and if there's anyone has any burning questions in public chat, now is the time to do it because we have maybe 2 or 3 minutes for the call. But Bill, we were talking earlier about how the EEOC has been really a successful ally in the gender violence and the immigrants' rights movement in terms of working in the agricultural industry. And and I know that in urban settings there are the same kinds of huge problems. What are some things that we can do to start building those networks and start being able to uncover, the pervasiveness of sexual violence, for example, in the janitorial setting, in the healthcare setting, in the hospitality, industry, in the domestic worker industry? Do you have any thoughts on that?
Well, that's a good question. For the EEOC was actually quite easy to get into the farm worker community because there has been a historical network of legal services and advocates trying to address the issue. It was a matter of the EEOC plugging into a network that existed. I think the difficulty in the urban areas is many workers, particularly in hospitality or janitorial, don't have existing worker organizations to help them. They don't know where to go. I've done some education with the SEIU, with the hotel and restaurant employees, but that has not yet led to cases coming to us in any significant amount. I think this is a whole new area to try to approach. I know the San Francisco Human Rights Commission, we just held a hearing last month, about the extent of sexual harassment in San Francisco, particularly for immigrant women. So at least it's putting the spotlight out there. The difficulty for some unions is that the perpetrator, while viewed as technically as a supervisor, is really still a member of the union. So if he's fired, the union has somewhat of a conflict because they have to represent the perpetrator in his termination hearing. So it makes it a little bit of a problem. But I think getting involved with, I think it's also getting part of the sexual assault movement to better understand what's going on in the high-rises, in the restaurants, in the hotels where women are working. It's a major issue that they're very vulnerable. We know that women are being, in San Francisco, last year, a jury came back with over $800,000 verdict on behalf of a janitor, Latina, who was raped at the Ferry Building in San Francisco and then eventually terminated in retaliation. The company ABM is appealing that decision, but it's probably the tip of the iceberg.
Wow. So Bill, because we're running out of time, to reiterate some of those points, for the role of the advocate, beyond everything that you shared in working individually with survivors on possible filing complaints and supporting them through the process and the evidence collection, in terms of organizing, to try to find ways to strengthen those networks, not just a collaboration with the EEOC office, but also to sort of be more proactive about recognizing for the communities that we're working for, what are some of the vulnerabilities? Like one of the things that I did after meeting Bill was I started doing volunteer work with our local unions here and finding out what was going on in the hotel industries. And I'm Filipino and I'm an immigrant, and a lot of the victims were Filipino immigrant women. So I just started doing workshops for them, and it started coming out. Just like Bill said, it's like, oh yeah, we don't want to hear about domestic violence. We want to hear about, how we can, be safe from our bosses. So I think that is kind of really, really critical work. And then to go back to the thing about being honest, of we often don't feel comfortable talking about sexual violence in our communities. So how can we do this in a way that makes people feel safe, that encourages people to come forward and know that they're going to be supported, I think is really critical question for us as we move forward with some of these topics that Bill has challenged us to address. And I really encourage everybody to watch the PBS documentary. It's excellent. Nancy, did you have any closing thoughts, and Bill,
No.
before we close?
Well, that was a great closing, but I just wanted to encourage again for us to take on Bill's challenge. The EEOC is ready and willing to support us, but as frontline advocates, we have a great responsibility, because we know the conditions for abuse of power exist within our API communities and with the survivors and women that we work with. But all these cases are a lot of Latino women and farm workers, but they're not coming forward. So it's our place to help, and I appreciate everyone here who are building their capacities to help talk about this and to bring this up with our community members. So I want to thank you.
I just add, a lot of our cases, when I had jurisdiction over Saipan, the sexual assault cases were Filipinas. Victims were Filipinas. So.
And it sounds like, but Nancy, it sounds like based on what we're going to get through the chat, through what people are going to get a printed version of the public chat, or at least an audio recording also, that you and I can get, regroup and think about some of the follow-up possible webinars or API events based on people's interest here. So that's something that Nancy and I are willing to do.
So yes, please take a moment to respond and send me an email about your feedback and what you would like to learn more about. I know some people had specific questions about strategies on supporting victims and collecting evidence, and we would love to work with you directly on and figuring those out with experts like Bill. So please stay in touch, and I wanted to close given the time and wanted to thank everyone for participating.
Okay, thank you.
Thank you, everybody.